For this session, may I first invite on stage our moderator, Ms. Tanu Banerjee, partner, Khaitan and Company. May I request you to please come on stage? Thank you. You're welcome. Thank you. Who was the one to start the claps? Thank you for that. Thank you. Okay, next on we have Mr. Amit Bhasin, who is the Chief Legal Officer and Group General Counsel, Marico Limited. Thank you. Welcome on board. Roopa Vikram, she is the Assistant General Counsel, ITC Limited. May we have you on stage, please, ma'am? Thank you. Next up, Ms. Richa Pathak Purohit, Corporate Legal Counsel, L&T Limited. I'm sorry, she's not going to be able to make it today. Then we have Mr. Ranabir Basu, Legal Director, Mondelēz International. And Mr. Surender Sharma, Whole-Time Director and VP Legal, Secretarial and Corporate Affairs, Colgate-Palmolive Limited, India Private Limited. So, okay, could we please have one more chair? And look forward to an exciting, intriguing conversation.
Thanks.
May I also say that as we are running short on time, we would like to finish this sharp by 1:30. Thank you so much.
Good afternoon, everybody. Today's topic is, quite interesting, and I think I've spoken with my panelists sometime back. We have a stellar panelist members on the stage, all of who have spent several years in the FMCG sector and hospitality sector and have dealt with advertising and, authorities who govern advertisements since several years. Just for a quick context to what we're going to discuss in the next 40-45 minutes. Advertising is the most crucial tool for any business today, and whether you are an early stage business or a more established one, advertising generally would be at the heart of any business strategy. The purpose could be to increase visibility or to expand or to add business lines or even just to maintain your current status quo on operations. Every business strategy would generally start with advertising. Advertising sector as a whole is, of course, intersects with every other sector today. India has double-digit growth stories across sectors mostly. Advertising sector itself is reported to be growing at a staggering rate of 16% annually. So, interesting sector to talk about. Just quick context on the regulatory side of things. Generally, the advertising industry has been operating under a largely self-regulatory regime, which is overseen by the Advertising Standards Council of India, or ASCI as it is more commonly referred to. ASCI has a set of detailed guidelines on different sectors, different goods and products and how they should be advertised, all of which is consolidated under the ASCI code. Of course, ASCI is a voluntary organization as such, so the code generally applies to members of ASCI. But over the years, it was established in 1985, and historically now over the years, it's a very well recognized setup, very well recognized body, not only by industry members, but also by the Supreme Court and, under some of our legislations as well. On a more legislative side of things or a statutory side of things, we also have the Consumer Protection Act 2019, which is a more recent legislative framework. So governs advertising. Broadly, the contours or principles under both the ASCI regime and the consumer protection regime is that they both at a broader level prohibit misleading advertising, right? So that's what we're going to talk about with our panel members today. The idea is to talk about their practical experiences dealing as part of the industry with the authorities and how they've advised their respective organizations on advertising. With that, I'm going to bring in Roopa first here. Roopa, if you could, just share some thoughts on how the self-regulatory framework under ASCI has, sort of been working so far. Has it been effective? And typically, what does a complainant or somebody who's grievanced by a certain ad do? Right? Who can complain? Who can reach out to ASCI?
Good afternoon, everybody. We are here discussing a very interesting topic, which is advertising and the current regime. Before I respond to what the convener asked me about, I'd like to just do an advertising flashback. And people who grew up in the 80s with Doordarshan as one of the mediums of communications where advertisements was mainly played, and we actually awaited to see, advertisements rather than the programs that were being there, aired on Doordarshan. Who remembers the little ad, The Girl Under the Waterfall? I think one of the most successful ad campaigns which brought about youthful exuberance and innocence so well. And I'm sure, that ad holds the same sentiments if we see it today. And the other such ad campaign was, I think, the Hamara Bajaj advertisement, which, was competing against some very, very strong competitors who are multinational. And they try to connect with, the emotional quotient of this country rather than putting emphasis on the functional aspects of the product. And that also went on to become a very successful campaign. Now, coming back to the context that we are already discussing here is that if we were to view these advertisements in the current context, would they pass muster? Debatable, because there are so many things that one has to look at when we are dealing with advertisements. Caveat advertiser has become the new mantra rather than caveat emptor or otherwise. So I think that we have started a regime where, the law is such that we need to make sure most of the do's and don'ts before creative expression is actually conducted in advertisements as such. So looking at that, I think, we are going through a phase where we need to be extra cautious, but at the same time also allow the businesses to ride the wave, like the digital marketing era where there's so much of opportunity for marketing, and we cannot tell them not to ride the wave and advertise the product. So as general counsels of the company, we should give them a guidance as to how to deal with it, because the laws that apply to the old format also apply to the new format. So we need to be mindful of that and take the company forward with using these new formats. So coming to what Tanu was talking about, the self-regulatory body that was already present, I think ASCII has played a stellar role. And the three things that actually worked for ASCII is that everything happened voluntarily, whether the membership, whether the compliance, or whether the regulation or setting of standards. All of this was something that happened voluntarily by the members. So compliance was in their own self-interest to do that. And it has worked very well. I think the records show about 96% of compliance of ASCII decisions so far, and very far and few decisions have not been complied with, and usually by non-members. So I think by far it has been very, very good in making sure that the members comply on the whole with the ASCII code. If you look at the new kid on the block, which is the Consumer Protection Act in its new avatar of 2019, we can see that, many of the ASCII related code fragments are there in the act, but not very well detailed or very well covered, as well covered in the ASCII. So I think we are in the early days to see how this entire enactment will be implemented, but we have to be wary about it.
Thanks, Roopa. Great background. Amit, I'll bring you in here. I think Roopa spoke about the Consumer Protection Act. Actually, I'll just take a minute. Sorry about that. Amit, as I was saying, Roopa just spoke about the Consumer Protection Act as well. And there are some, overlaps in terms of concepts. Also, generally the principles are the same. But in terms of the framework, how is the ASCII framework different from the Consumer Protection framework? And did we actually need a parallel framework to start with?
Yeah, thanks, Tanu. I think it's important to understand a little bit of history of ASCII as well, and I think Roopa talked about it. But ASCII at the when it was started, at that time also there were discussions that there is a need to possibly regulate advertising in the country, and I think that was the time when the group of companies came together and said, "Listen, we don't need a regulation on this. We are happy to be self-regulated." And then it finally found its force through the television and cable network act, where it says that it has some kind of enforceability as well. That's where ASCII started. uh, However, despite ASCII kind of being the only body which is sitting with a host of knowledge on advertising, apart from courts of course who have kind of adjudicated on some of the advertising, uh, there was always this feeling with government that this is a space which is unregulated and people are making uh, advertising which is misleading to consumers. And I don't completely agree with it, but I don't completely disagree with that too, because yes, there are advertising which are in the space of saying grow your hairs in 10 days, get brighter skin in 5 days, those kind of a things. And some of the advertising which comes late night in some of the weird channels, of course those are the ones which is triggered, by the way, this thought of getting a regulation on misleading advertisement. Now if you look at this regulation, it is cut copy paste, I would say. Roopa, actually you will agree with me that it is 90% ASCII code. It is 90% ASCII code, bit loosely drafted, leaves a lot of scope for interpretation, but the principles have largely remained same. And I think from therefore the companies which were following the ASCII code and which were therefore member of ASCII currently would not have much of the issue in complying with this. I think what is to be seen is the enforcement and how really the enforcement happens, because in ASCII it is essentially if you find a advertisement to be objectionable, or someone finds your advertisement to be objectionable, they can reach out. There's a well-laid process of CCC where you are allowed to make your submissions. The principle of natural justice are followed, and within a defined time frame largely that which part of your advertisement is creating a problem or not following the ASCII code. They will make a recommendation, you will have to change it. If you are fine, if you're not okay with it, there's a provision to appeal as well. They have got now retired high court judges who really adjudicate the matter. They have experts now who are sitting on their panel if it is a very, very expert technical claim that's there. So I think that infrastructure has been built at ASCII level today. It will take some time for CCPA to build that kind of a knowledge base, is what I feel, because advertising as a space gets a little technical at various points, when particularly you are making very, very technical claims, scientific based claims. It gets too technical at time, and therefore you need that expertise. So I think that is to be seen how regulator are going to bring those experts while adjudicating on some members. It's good to say that I think in the law they have created that provision that if they require, they can bring a body of expert to kind of take opinion on some of the advertising. But I think we'll have to still see how that pans out.
I'm also going to bring in Surender here as well. Surender, similar question to you. One, do we need two parallel frameworks? And Amit, of course, spoke about the origin of it and, why the government sort of perhaps found it necessary to have another legislative framework as well. I think recently the Consumer Protection Authority also came up with specific guidelines, right? And which, further detailed out contours of misleading advertising and surrogate advertising, bait advertising, etc. Just your thoughts on was that necessary? Are there overlaps? Are there, still gaps in the two frameworks?
Thanks, Tanu. I think if you talk about the overlap, definitely. The objective of both the agencies is to protect the consumers from misleading advertisement. And to that extent, there is multiplicity of proceedings. And I would like to add to one more. There is a sector regulator also, which each sector regulator, for example, food, is governed by FSSAI. That law also talks about misleading advertisement. So at times the sector regulator also initiate the proceedings for misleading advertisement, whether it's a Food or Drugs and Cosmetics Act. So I personally are facing a single complaint filed at multiple proceedings and three forums. Thankfully, I think ASCII has taken a very practical and pragmatic view. that if something is lying with or is being dealt by the regulator, they will not proceed with the with that particular complaint. Having said that, I think when we have multiple regulator also, it becomes quite challenging. So I think the need of the hour is to there's some sort of synergy and between the regulators. They should talk to each other who will have the overriding powers when it comes to advertising. And just I think both Roopa as well as Amit has talked about the history of both ASCII as well as CCPA. ASCII is dealing with advertising for more than 37 years now. They were set up in 1985. There's a lot of expertise available. They have been I think they have traveled in terms of their journey. They have evolved a lot. I'll not say that evolution is complete. It's a journey at the end of the day. The ability of ASCII to come out with regulations on new evolving subjects is very, very fast. On the other hand, I think CCPA is just, they have come on the center stage about a couple of years back, and I think, as Amit has rightly pointed out, those aggressive advertising and claims on some of the products which get advertised during the late night hours, as well as the COVID, I think, was another example when people were making all sorts of claims. Anything and everything was giving COVID relief to people. I think that point in time, the regulator thought it's high time that we, as a regulator, take responsibility and govern this particular space. In my personal opinion, I think they have been fair as of now. They have borrowed a lot of concepts from ASCII Code of Conduct. I think way forward for the regulator is to work in tandem. If they can use the expertise of ASCII in dealing with this particular space, I think that will be great, in my opinion.
Great, thanks, Surender. I think both Amit, you and Roopa, all three of you sort of, and I share the same view, that there are significant overlaps between the ASCII regime and a lot of what is borrowed in the legislative framework under the Consumer Protection Act is actually borrowed from existing principles under ASCII. So, Ranbir, on that note, how does that pan out for consumers? Because at the end of the day, all of this framework is meant to be and is set up and in fact in the interest of consumers, right? So what does a consumer do then? Does it go to ASCII? Given that ASCII has perhaps more experience in the sector, like Surender pointed out right now, or does it go to the government or a more statutory body under the consumer protection regime? How does one make that choice?
Sure, thanks. So just before I get to that question, Amit did mention something which says grow your hair in 10 days. Clearly, I missed that advertisement. So that is
or you missed the product.
I'm still waiting for it. Maybe it's not too late. But look, very interesting question. Thanks, Tanu. And so my short answer to that is we'll have to wait and see. Because, just to share with you a few data points, I was just browsing some statistics last night, and an ASCII website shows that, basis the complaints which they have received, between 21 to 22, they've got something close to about 7,600 odd complaints. 25% of those are from consumers, okay, and almost the majority, which is close to 73 or 72% of them, are by ASCII themselves. So instinctively, if a consumer looks for legal advice on a misleading advertisement, it shows that they still go to the ASCII, or the lawyers recommend that they could recommend refer the matter to ASCII. Now, I'm not opposed to a new legislation coming in, and again, from a consumer point of view, I think a legislation which says consumer protection is a natural thing to pick up. What is going to be interesting and fun and games is how the interpretation of the new guidelines work out. Because, the day the regulation came out, I think we all gave a reading to it, and we see that there are some overlaps. They overlap with some sectoral regulations. they overlap with ASCII code. So it's really time which will tell, is this really a beneficial legislation for the consumer? Clearly, the intent is that, but whether it actually turns out to be, I think time will answer that.
Got it, sure. Surender, back to you, again on the process. And Ranbir, of course, said we'll have to see and wait and watch how effective the alternate, regime would be. But generally, as a process, and ASCII has been the overseeing governing body, so to say, historically. How does the enforcement happen? Let's say, and I know that ASCII has a complaints council. Which is sort of the single body that sort of deals with complaints and corresponds, and we've advised several of our clients in correspondence with them. But eventually, how, once the proceedings are over, how does the enforcement happen?
I think Amit also mentioned and touched upon this particular aspect, but as we all know that ASCII is a self-regulating body. It has its own members. So enforcement vis-a-vis the members is very easy. Members themselves, they have abide to the code of conduct for self-regulation in advertisement. So they are bound by the orders of ASCII, and they themselves feel that if something has been ruled by an expert panel, that is CCC, then I need to either modify my claim or need to come out with a new advertisement. So enforcement of ASCII orders vis-a-vis member is there's a fairly good amount of enforcement rate which is there. The challenge comes when there is a ruling by ASCII against non-members. So non-members can always say that I am not part of this self-regulating body. It doesn't have a statutory force. There are some mechanism through which ASCII try to put pressure on the party is by writing to Ministry of Information and Broadcasting, and some of the members, the media channels are member of the ASCII, so they say that if something has been ruled by ASCII, so they will not air that particular advertisement on their TV channels. So these are some of the indirect ways of enforcement against non-members, but then non-members have a tendency to rush to the court and get some sort of stay. So it becomes quite challenging, and hence it becomes important for ASCII to collaborate with the regulators, get some sort of statutory recognition. So there are some statutory recognitions available in, as Amit mentioned, in cable and TV network law. Similarly, they are also trying to sign some sort of MOUs with the Ministry of Consumer Affairs. They have earlier in the past had signed MOUs with Ministry of Ayush. So if they can get some sort of recognition and then force for enforcement of these kind of orders, either through Consumer Protection Act or any other way which the regulator feels appropriate, that will be great in terms of enforcement.
Yeah, so you brought up an interesting point that broadcasters will generally take off an advertisement that ASCII has ruled against. That part of the reason for that is also that while ASCII is a voluntary body, the Cable Network Television Act, which governs our satellite broadcasting or TV channels, so to say, actually statutorily recognizes and says that advertisements to be played on channels need to be compliant with the ASCII code. So that's somehow into the legislative sphere as well, and perhaps that's why television channels, the enforcement is easier on TV channels. But today the problem is that TV is just one of the mediums today, right? So maybe a television broadcaster would take it off, but then that legislation and that framework does not apply to the digital space.
Completely agree.
Right. So then, so what happens then? So does members, you said, will take off the ads because they've signed up to comply with ASCII, but non-members then is it then lacking in force in that sense?
So there are challenges, and I think it is now important for ASCII to make all these technology platform also as part of its membership. That will help in terms of enforcement, and I'm happy to hear from others.
Yeah,
Just
Roopa.
add to what is already spoken
Sure, Roopa.
here is that certainly the trends on digital marketing is picking up by the day, and content creators are also becoming marketeers to some extent, and therefore ASCII has actually passed certain guidelines for influencer marketing, and the latest one is also on the celebrity endorsements, which even the CCPA recognizes as being one of the important elements of regulation. So the influencers are also being told that when you are doing any promotional content, you need to do the 2 Ds which you need to comply with. One is do your due diligence, and to put the disclaimer that this is a sponsored, and by and large this is being complied with if you look at the internet space in terms of advertising, where influencers are being used for certain promotional activities. So ASCII is actually up to date in all these, catching up with these trends and seeing how they can regulate it. But the trends are galloping in such a manner that I think organizations also need to have their own guidance documents to make sure that any marketing that is conducted on this OTT platforms or your social media platforms are something that are governed and comply with the code and comply with the CCPA guidelines. I think that becomes very paramount in self-regulation.
Just to add what Roopa has said, I think a lot of these influencer marketing campaigns which are being at the regulations which ASCII has come out, and influencers are complying with it. I think a lot to do with Instagram and all these companies becoming member of ASCII. Again, when they are becoming member of ASCII, they are adhering and giving an assurance that they will adhere to the code of conduct. So it becomes important that the ASCII to bring more and more advertisers and those platforms as part of their, the membership of the body, and then enforce the orders.
Right. My follow-up question on the endorsement and the influencer side would be, and Amit, maybe you could also share your thoughts on this one. Of course, both the Consumer Protection Act, ASCII has a detailed set of guidelines also on how endorsers, influencers should sort of advertise, promote. But is that compliance actually happening at an individual level, right? And then what are the consequences? There are some financial penalties under the Consumer Protection Act, but is that enough? Is it actually a deterrent for people to comply with it? Because honestly, when I see it as just a layman, there are people who comply with it, people who don't comply with it. A basic, requirement of having a disclaimer that this is a paid promotion and have a collaboration. Not everybody follows it today, right? Is the regime enough then?
So I think, the point made by Surender, Roopa, all of us is that yes, the shape of advertising has changed in last few years, and it has changed rapidly from only a TV-based advertising, which Roopa talked about on Doordarshan, now today to bulk of advertising budgets of FMCG companies being spent on digital. I think what we are talking about therefore is a big shift. And I think compliance therefore has to do with 2 things. One is the sheer awareness. And I think there is a job to be done there as well, where the awareness has to be raised with the content creators. The awareness has to be created with the marketeers and with the influencers as well. ASCII has done this very good job, which Surender was talking about, where they now track a lot of this influencer marketing online, and then they write to the company and to the influencer. And I think the compliance rate there is very, very high, right? So if people are aware that there is something they are supposed to do, I have not seen a reluctance to say, no, I will not comply with it because I am not, at least at the influencer level, that problem is not there, that I am not the member and therefore I will not comply with it. People are largely okay to do it, and therefore, again, ASCII has started this thing of informal resolution, where if they raise the issue and you resolve, you just say that I have complied with it, the matter get closed very, very quickly. So I think awareness building, and there's a culture shift we are talking about, where if you are doing something and getting paid for it, please come out clearly and say that yes, I'm getting paid for it. So coming back to your question, yes, it will take a little bit time for us as an industry to build that culture across all the stakeholders, but I don't see a big challenge over there. And I think if you look at CCPA guidelines, it does not really talk about influencer marketing anywhere in clear words.
Amit, it actually talks about not influencers specifically, but it does talk about endorsements.
endorsement, yes.
And right, and it, in fact, I think what I find peculiar in that regime is that it goes on somewhere to say that endorsers should do their own due diligence.
That's right.
Which I think, I don't know, at a practical level, is that possible for influencers to do? And as brands, when you engage with somebody, are there, what are the terms? How does one ensure that an endorser is doing its own due diligence on a product?
Yeah, I think it's a great point, and I think as an industry we have kind of debated this a lot, because this has been going for a very, very long period of time, where there was a time where the provision said that actually you get into the technical details of a claim. So let's take an example. I go back to the example of grow hairs in 10 days. Let's take that example of grow hairs in 10 days. If there is a celebrity who want to endorse that, the celebrity need to get into the details and understand the technical data based on which he or she is endorsing that. That was really the expectation was. I think to some extent even today that the expectation is. I think the way as companies we are managing this is this, that at least whatever data is there, you make a transparent disclosure to the celebrity who is endorsing it. I think that's the first point, that you tell the celebrity very clear that this is the claim I am making, and this is I have done my due diligence as a company. Anyways, I am required to do my due diligence. I have done my due diligence. I have sufficient data to support and substantiate this claim. That kind of assurance at least is definitely required. If any celebrity wants to get into the detail, I think they have right to get into the detail. And as a responsible corporate, you will have to then tell them that this is the data is. So, but generally it is covered from an agreements point of view, where in most of the celebrity endorsement agreements, there is a covenant which says from a mutual point of view, the company will disclose all the data and they do their own due diligence before getting into any kind of advertising. So that's where the regime currently is. I think it was also a right thing to do, because it puts some amount of responsibility on the people who are big influencers and big celebrities, where people just take them on face value, right? And I think it was an obligation that has been put on them, saying, guys, if you are going and telling public and consumers at large about a particular thing, at least check at the threshold level that you are not telling something which is absolutely false. So I think which is fair to that extent, and therefore again I see a little bit of change in the celebrities' attitude as well, where they are asking some of the right questions. I don't think they need to get into a lot of detail till the time company is able to give them assurance that we have done our due diligence and we have data to support the claim. So that's how the process currently is working. As I said, it's a big shift from a space where celebrities have nothing to do. They just come on the shoot, say whatever they have to say and just go off. That was their responsibility, to a place where they are now expected to get in a little bit into a technical detail as well. So it's a shift that is happening in the advertising space, and the shift which is good for the consumers and stakeholders. It will take a little bit of time to get it completely seeped in across the industry.
Tanu, can I just jump into the
Sure.
So one of the things which we've noticed, which has worked in the ASCII regime is, just for a change, we're not just talking about imprisonment and fines. The largest number of cases is actually almost a win-win, where the parties have kind of agreed, or ASCII has given a direction that you modify your ad. Now we all know, as FMCG or any other kind of companies, there's a lot of money which goes in there, and sometimes wearing our business hat and the business wearing their legal hat, we take a joint call somewhere that this is a gray area, let's take a risk. And when you can modify an ad, someone sits with the marketing department and says, look, we tried it didn't work. Okay. But at least your entire ad campaign doesn't go for a toss, or at least it shouldn't be just based on that premise. The whole thing shouldn't be at risk. So that's just one thought which I wanted to add as well.
Got it. And with all of this shift, and Ranabir, again, question to you, only just taking a cue from what you just spoke. With all of this shift that Amit spoke about, right, and there are different guidelines for endorsers, for different sectoral businesses and so on, plus there are parallel regimes right now, how are the businesses also sort of dealing with it and coping with it today? Is there a heightened level of consciousness, due diligence, or does it seem like a safer space to play with? How is that planned out?
So, thanks. I'm sure all the lawyers in this room would be smiling for that one. Well, they are giving us a hard time, okay? So it is difficult for them to cope as well. I think you touched upon it. One of the best solutions is awareness. It's important for the business to know that the law is changing. The government and regulators are becoming more aware, and I think a lot of this depends on how we can keep them up to date. And the marketing folks and others in the company, they are smart guys. They understand what we're trying to tell them. This back and forth of how much we can do, that will always continue, and that's why we are in the companies nowadays. But today there are new concepts such as moment marketing. With the advent of digital and technology, these concepts wasn't possible. It just wasn't possible, say 10-15 years ago. But that's when we also have to train them or come up with some safety guidelines after we kind of study these complicated laws ourselves. Try and give them a cheat sheet which they can use, so that when they come for a moment marketing and they say, hey, look, this is a 24-hour hit. I don't have time to run through legal. And that's when we also have to kind of adopt to say, okay, if you want to take that risk, then this is the 10 checkpoint which you have to go through. So one solution.
I think I'll just add to what Ranabir is saying, and possibly again reiterate that awareness building is the single most thing that you can do. And without sounding like promoting ASCII, I recently got entire marketing team of mine into a ASCII masterclass, where the ASCII team came and trained them on the rules of the game. And it's important to keep on reiterating them because the way things are kind of changing. And I think the principle again is not about that advertising in question. It's about reputation of yours as a corporate, right? Because bad advertising can have a serious damage on the reputation. I think the things we are talking about of movement marketing, one advertisement where you have shown something in a bad light which can have a social implication. ASCII has come out with this gender next guideline now, which is talking of bias against a particular gender, showing something in the advertisement. And just to give an example, it was okay to show in the advertisement some days back that the male of the house is coming back and the female is just serving food. Possibly it is now no more acceptable, right? I'm saying, and that's not a legal lens, that's a social norm which is changing. How you deal with the LGBTQ community in advertisement is a social norm you have to now evaluate. So I think the spectrum has changed a lot. And this continuous training of your marketing team and in-house people to say, guys, whatever you show in the advertisement can not only impact this particular ad, but the reputation of your corporate is a larger point that as lawyers, I think we need to drive continuously.
Great inputs, Amit. I think on that one, on how the social framework is sort of also changing advertising, video making, content making in general. Roopa, and on that note, how is the role of advisors as in-house counsels, GCs, or external advisors? How has their role sort of changed over the years?
I think it's not over the years, it's overnight. Our role has changed over its head. Yesterday, pursuant to this particular panel discussion, I had a discussion with my marketing head saying that what are the different formats of digital marketing that you're exploring, where branding can be done, branding exercise can be done. And he came out with so many new things. I need to educate myself before I can start educating them on what to do and not to do. So he told me about some GIFs, he told me about metaverse, he told me about NFTs. I said, wait, hold on a minute. I think I need to spend half a day with you to understand what are all these formats before I can, start giving you advice. For instance, this requirement of giving disclaimers. Where and when in these digital formats will you give these disclaimers? And the CGPA says that it has to be, voiceovers, or it needs to be in the same size where claims are being made. So there are, very, very edgy difficulties to deal with when you're looking at digital formats. So I think there's a lot of learning for us also involved in the new formats of marketing, as well as, giving them a guidance as to how the same rules apply, but, in a different way. So I think that is something that we need to be updated about, and therefore, we can advise the companies better. And of course, we can't completely hold them back. We should allow them to ride the wave, but ride it responsibly.
Great. Surender, you want to add?
Yeah, just wanted to add, I think that brings us to the morning session of advocacy, where the role of GC is to play a bridge between the marketing here in this particular case as well as to the regulator. I think what we need to do is, while we have to create the awareness amongst the marketing folks, tell them about what the regulation thing, is how they are evolving and how we need to ensure that not from one regulation point of view, but multiple regulations point of view, how their advertising need to be created. At the same point in time, we as a GC needs to continue to interact with the regulators and ASCI as an advertising agent, the regulator, self-regulatory mechanism, and then continuously talk to them in terms of bringing in change and adapt to the new technologies, new mode of advertisements. So, as we know that now government is more willing and eager to listen. I think we as a advocate of to protect the interests of the company, we can take up these issues with the regulator and bring about an influence in terms of regulation making.
Thanks, Surender.
Just to add one point which I missed was, we definitely need to impress with the CGPA that, please onboard ASCI for determination of disputes, and we can use you for enforcement, because that is the gap that really needs to be filled here, because enforcement is the gap that ASCI lacks, the teeth of enforcement. So please onboard ASCI for determination of misleading advertisements, while CGPA can always be held for, enforcement of the same.
Great. I'm going to take a quick pause and just any questions from the audience. Yes, sir.
Thanks. Interesting perspective from all of you. Two small queries. One is on free claim advertisements. I think everybody knows that such products which are given as free is actually a markup. Somewhere it's there. Whether it's one commodity along with bundle with other, or in other contexts like a card with a free membership, or even in real estate, stamp duty is marked up and says it's free. So in the new context of the guidelines, how does one address? Because when an investigation happens, how do you defend that by saying that whether it's or not? That's the first one. And the second is the endorsement penalty, which is currently at a very small amount of 10 lakh, is insignificant to the endorsements big people have. So would it make sense if the endorsement or the penalty is a percentage of the endorsement to really implement and see people do that?
Amit, any takers?
So to answer the first question on free claims, there are always, certain add-ons to an existing product. So nothing is just given free of cost. So wherever any marketing of a product is done, for instance, 1+1 or something extra is given along with it, or a free, let us say, a product is given along with the purchase of another product. So all of this is something that is an add-on to a sale. It is not independent of the sale. So in that sense, nothing can be completely free. It has to be, coupled with the purchase or coupled with the sale of a particular product. So if the product itself, which is offered for free, it can be easily substantiated that it is not costed for, which means that there is a base price on which the earlier product was sold, and something which is given free of cost is something that is not adding on to the price that already existed. So it is very easy to substantiate that. And if companies are genuinely giving something free with an add-on, it is very, and of course your GST returns will also show that, what has been given free and what has not been given free. I think that is not so much of a problem, but yes, the new laws are a little ambiguous to that effect. And there is no such breakup in price when we talk about packing or sealing and all of those things. It's all clubbed as an MRP. So I don't see that we can give this kind of a breakup of what are all the price points of a product. So that is something that's going to be difficult, but free can be definitely established from a benchmark of what the product was already sold at.
I just would like to add, I think completely agree with Roopa. I think for big organized players, it's not a problem at all. If someone is trying to cheat by barking up, I think it's in all fairness that investigation should happen, and it should be booked under the Consumer Protection Act. That's my personal opinion. I think we all good organized companies, they have a good rules and their internal code, how they will come out with free, and they will not, they have, they will ensure that they are not increasing or marking up the price when the offer is coming up.
However, in the new guidelines, if you see, there is a concept of bait advertising, which loosely is what you are talking about, possibly not if exactly that, but it is.
7C, when I was looking at that,
Yeah.
you have to pay for it.
Yeah. So basically, it is saying that you are giving an offer which looks too attractive or too kind of good to be true, and then you try to get consumers, and then they have provided certain guardrails around it that you have to ensure that these guardrails are there so that it does not classify for that kind of advertising. I think on your other question of celebrity related this thing, as I said, I always believe that it is a cultural shift. It's not about amount. It's a cultural shift that you are talking about, and therefore, if a celebrity is a responsible celebrity and they just had this 10 lakh penalty, also I think the reputation damage that it causes is much more than the amount that they pay, and therefore it's not really about the amount for them, but just to get that culture right, that if you are endorsing something, then you better take responsibility of that.
I think, and just to add to that, one is the financial penalties, which may or may not be, high for depending on who the influencer is. The other is they can potentially be barred from endorsing also for 1 to 3 years, I think, right? That's the time scale. And that could definitely be a deterrent, I think, for somebody whose livelihood is dependent in some ways on these, sort of endorsements and influencer business. So I would say we yet to see enforcement of it, but there's enough provisioning, I think. Any other questions? Okay, great. I'm going to wrap this up with just, one final question, just closing thoughts from each of you in terms of what advertisers should keep in mind going forward, looking at the current gaps, regime, overall framework.
I just want to make 3 concluding points on this entire discussion. One is, as I already suggested, that ASCI should be co-opted with the CGPA to determine the disputes. I think that would be a great win-win situation and a balanced approach in terms of governance. And 2 is, I think, when the enforcement of CGPA is going to happen, I think some regard should be given, or some latitude should be given to MSME players, which, with small marketing budgets, and they don't have, the reach of the big brands. So we need to have some sort of a latitude in these kind of situations. And 3, of course, is we shouldn't forget that commercial speech is part of freedom of speech, and therefore we should seek for enforcement of this whenever there is a very, very harsh clampdown by CGPA of our rights to freedomly, or creative expression is suppressed. So these are the 3 points I'd like to leave for consideration in closing comments.
Surender, you want to go next?
Yeah, just to build upon what Roopa said, I think a single framework for regulating the entire space will be good enough. And I think Roopa also touched upon the freedom of commercial speech. I think there's a fine line, and if regulator, when deciding on any of these misleading advertisement, if they can keep a good balance of what is creative and where the line is getting crossed, that will be great from the regulation point of view.
So, message to advertisers: advertise responsibly, believe in your brand and your product, and please listen to legal.
That we all agree with.
I think I still believe that advertising is all about telling a story and telling a good story, and there has to be a fun part into this as well. We all remember some of the very, very good advertising. So I think the first part I will say, don't take fun out of the advertising. It is the art of storytelling. It has to continue. Of course, it has to be responsible. Of course, it has to be in a way that it is not misleading to the consumers. But I think all the stakeholders, when we talked about endorsers, we talked about celebrities, we talked about influencers, government, companies, all have to come together to create a regime where advertising become more responsible in the country. I think that's the only thing. And if you really go to the core of the rules which are there, they are simple. There are no rocket science in this rule. There are simple rules to say responsible. Don't make it something which is misleading. So I think you can follow it easily. Yes, multiplicity of regulators we all talked about. I think if that can be avoided, that will be great. But I just hope that advertising live long in this country.
Great. Thank you to all the panelists. We'll wrap up our session here. Thank you very much.